officially. Case number 117910 in the matter of David P. Crandall.
May it please the Court, Stan Hazlitt appearing for the Disciplinary Administrator's Office. Mr. Chief Justice, I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
This is an original proceeding in attorney discipline. The panel hearing in this case was heard on December 19th and 20th of 2016. The respondent at that hearing appeared with counsel in person, Tom Hamill. Mr. Hamill later withdrew on July 20th of 2017. The panel issued its report on June 28th of 2017 and found violations of competence, diligence, communication, 2 counts of unreasonable fees, a conflict of interest, and conduct prejudicial to the administration of justice. The matter was docketed with this court on July 3rd of 2017. The respondent took exceptions to all of the conclusions of law, many of the findings of fact. Briefs were filed, and we're here today to argue the briefs. The hearing on this case involved evidence presented in 2 separate complaints. The first complaint arose out of the respondent's representation of an elderly couple, BA and VA, BA being 87 and VA being 84. Initially, the objective of these 2 individuals was to preserve their assets from the expenses of long-term care. At the first meeting, the respondent did determine that BA and VA would be eligible for VA aid and attendance benefits. In the second case, this was filed by a district court judge in Johnson County. It was arising out of an estate in which the respondent had represented 2 different executors in the estate. It was a 1-asset estate, a house appraised at $70,000 when the estate was opened. In both of the cases, the panel found that the respondent had charged an unreasonable fee in violation of KRPC 1.5. In the estate case, the judge assigned the probate matter in Johnson County, had found the respondent's fee in the estate was unreasonable after hearing evidence about the respondent's fee, and the panel later on concluded that the judge was right, it was an unreasonable fee. The remainder of the allegations or findings of misconduct, the competence, diligence, communication, conflict of interest, and conduct adverse to the prejudicial administration of justice all occurred arising out of that estate case. The unreasonable fee and the representation of the elderly couple, there was only the finding of the unreasonable fee. At this time, as I was sitting back in the attorney lounge looking at my notes, I noticed that my brief, at page 3 of my brief, there is a mistake on page 3 of my brief, and if you look at the first full paragraph on that page, in the last sentence, and here we're talking about the representation of the elderly couple, the last sentence of that first full paragraph said, if calculated as a percentage of the value of the client's gross estate. Client's gross estate, by the way, was $472,000. Mr. Crandall's fee was just over 18%. That's incorrect. That's not the right number. It's 5.48%. So that's a significant difference, obviously. And when I saw it this morning, it was obvious to me that I needed to bring it to your attention immediately. I can tell you that the only place in the record that 18% figure appears is in this brief at that one point. It was not argued in the case itself that the fee was 18%. There was no reliance by the panel in the record on the 18% figure. It does not change my view that this was an unreasonable fee. It's just that mistake that appeared one time in this brief. Apologize for that mistake, but obviously you needed to be aware of it. Mr. Crandall needed to be aware of it. First, well, there are actually 8 issues raised by the respondent. There's not enough time in 15 minutes to address each one of those 8 arguments, so or 8 issues. I'll rely on my brief on the issues that I don't discuss with you this morning, and obviously answer any questions that you have of me. But the first issue that I do want to discuss is the respondent's argument that the panel abused its discretion by denying admission of the pre-filing investigative reports in the case. These 2 reports were prepared by attorneys appointed by us to investigate the matter, and they resulted in 2 investigative reports, which were offered at the panel hearing itself. Respondents' counsel advised the panel that the reports could act as a guide for the panel when he attempted to offer them. I objected for 2 reasons. Number 1, these reports are full of hearsay. Number 2, they're full of opinions and conclusions as to legal and factual issues that are before the panel itself. The panel sustained my objection due to hearsay and that the reports contained opinions on the ultimate facts which the panel was to decide. After this matter was docketed with the clerk of the appellate courts, the respondent requested that the 2 reports be added to the record. And on January 10th of 2018, the reports were added to the record, but were placed under seal. So they are at your disposal, obviously. The respondent first argues that the reports should come in under many hearsay exceptions. Problem with that is that he didn't argue any hearsay exceptions under which they would be admissible at the hearing itself. And in fact, if you look at his brief, he doesn't really argue, although he mentions that there are exceptions, he doesn't really argue why those exceptions apply. And under those circumstances, I don't believe that the respondent should be allowed to argue that those grounds are a basis for error. But
well, I'm not sure exactly how to phrase the question. I'll just put it bluntly, I guess. Why work so hard to keep these out? This isn't the same kind of a proceeding that follows strict rules of evidence. There's a measure of equity to these disciplinary proceedings.
Sure.
Why not simply permit the panel to consider those reports?
Well, I guess this is an unusual situation. We all know what happened here. I mean, the investigators in these 2 complaints concluded that there was not a violation of the rules. That's not entirely correct, because in one case there was a finding that the respondent had billed out 2 hours of secretarial time, I think, at attorney time. So they concluded there was an unreasonable fee there. Later on, obviously, as the case goes through the process, those investigative reports go to the review committee. It's that committee of 3 lawyers that decide who should, whether or not there's a violation of the rules, probable cause. Fact is, I'm not trying to act like that this is a noble cause on my part, but the fact is, this doesn't really happen very often where there's been a finding that there was no violation.
Right, and that's why it just seems like I can at least have some sympathy for the view that this isn't fair.
Well,
just on broad fairness principles.
I would argue in the vast majority of times when there's an investigative report where the investigator concludes that there is a violation of the rules of professional conduct, I don't think it would be fair for me to have that sort of report with all sorts of hearsay in it, all sorts of conclusions made by the investigator, maybe references to interviews they had with witnesses.
But that's in part because you bear the burden of proof. I mean, if you analogize to law enforcement, if there was an affidavit in an investigatory file from a law enforcement officer who submitted an affidavit that said there was no crime here, and then the state tried its best to keep that information from the fact finder and from the court of that's what I'm struggling with.
Well, I understand your point completely, but the respondent had a lot of opportunities to enter these investigative reports properly. There was a pre-hearing conference in this case. That issue was not even brought up. There was obviously at the beginning of the hearing, I objected to the admission of these 2 investigative reports. Again, there was no talk of hearsay. I just said, look, I mean, I objected on the grounds of hearsay, but there was no argument that they were admissible under any sort of exception. Respondent bears some responsibility to introduce this evidence in a proper way. I mean, if he wants to view it as expert testimony, which he did, that's what he said, I mean, the investigators weren't even there to testify or to be qualified.
Could he
as
have
experts.
called the experts in his case in chief, or when he's presenting his evidence? Could he have called these not experts, excuse me, the investigators to?
Right, I would make that distinction.
Yeah, could he have called the investigators to testify as to what they found?
Well, yes, I think the investigators certainly could be witnesses in this case. I would have objected, though, if they started talking about evidence that would have been considered hearsay. I would have objected if they started talking about their conclusions as to whether a rule was violated, or their opinion about some sort of factual issue, which I just don't think is admissible, especially if you don't do it the right way. But I mean, here it is. I mean, the reports are before you. You know exactly what they said, and you can see their reasoning why. I obviously disagreed with it, and so did the review committee.
But the panel didn't see it. Am I right about that?
That's true. That's correct. The panel did not see either report. Second issue I want to discuss is the actual findings of unreasonable fees in the two different cases. In the case where the respondent represented the two estates, the two executors in one estate, there was a $16,388 fee and a $35,000 estate for an estate that was open for 7 years while the respondent was involved as the attorney in the estate. He argued that the amount of the estate should not be considered in determining the reasonableness of the fee, but I don't think that's correct. I mean, I think the amount involved in the estate could clearly be considered by you, because one of the factors is the amount involved in the results obtained. There really were no significant results obtained in this estate. I mean, two executors were appointed, the will was admitted, but by the time the respondent got out of the case 7 years later, that's all that happened. So the amount involved, $35,000, I think is an important factor you to consider. The judge found, and the panel agreed, that the issues were not particularly novel or difficult in this particular case, and that nothing really had been accomplished, the results obtained, nothing really had been accomplished in the 7 years. The second case, the estate planning matter, the more significant case, this is the case in which the respondent charged and collected a $25,855 fee for his services. VA in their 80s came to the respondent wanting to protect their assets from the expenses of long-term care so that their assets would pass to their kids. The fee the respondent charged, according to the respondent, was purely for Medicaid asset protection planning. During the representation, he did determine that BA and VA were eligible for VA benefits, aid and attendance benefits, but he said that advice, that did not factor into his fee. In fact, it would have been a federal crime to charge a veteran to apply for those benefits. The Veterans Eligibility Trust, Exhibit 13, would accomplish, our experts said this, would accomplish what BA and VA wanted, to become immediately eligible for aid and attendance benefits, and to protect their assets, for their children if they met the 5-year look-back period for Medicaid eligibility. The respondent testified on the issue of whether his fee was unreasonable, and he indicated that he felt he had provided excellent estate planning services, in his opinion, that his expertise was as a result of belonging to a nationwide group called the National Network of Estate Planning Attorneys. It's a nationwide group of lawyers, according to the respondent's expert, that contribute ideas to each other for better estate planning, that have software for document preparation, they have educational seminars. He testified that this group focused on a client-centered model, focused on client counseling, versus what the respondent described as a transaction model focused on document production. He's critical, the respondent was critical in his testimony of what he considers to be the entrenched legal establishment of probate or estate planning lawyers. He claims that they have relegated estate planning to little more than a mere document production. He included in his brief Mr. Ridenour, one of my experts, Stacy Jansen, one of my experts, Jeff Chubb, one of the members of the panel, as being in that establishment group. He said that those estate planning attorneys are nothing more than glorified paralegals that conduct some minor word processing on long-established forms. I would say, I know my time is close to being over, I would say, I would invite you to look at the trusts that were prepared by the respondent in this case for VA and BA. In spite of his claims he was adverse to using forms, and in spite of his claims that he tailors his work for specific client needs, take a look at the revocable trust. It's a 155-page revocable trust to administer $95,000 in assets. Both of the DAs, of our experts, Stacy Jansen and Phil Ridenour, with a wealth of experience in this area, testified that an 11-page trust that already existed took care of all of the things that this 155-page trust sought to achieve, and that there were numerous unnecessary provisions in the 155-page trust. I don't know just where I stand on time.
You're out of time,
Okay.
but I'll give you 30 seconds to conclude, and then we'll see you on rebuttal.
Okay, well, I will say that with respect to the irrevocable trust, the VA trust, which achieved basically what the Alvarados wanted, VA and BA, I'm sorry, that Stacy Jansen testified that she could have consulted with these folks in an hour and a half, explained to her what their options were, prepared the documents, would not have precluded other employment. Her fee for this type of work would have been anywhere from $3,000 to $8,000. Actually, what she said was that the fee in the Kansas City area would have been anywhere from $3,000 to $8,000 for that sort of work. And I conclude by saying that she also testified she prepared 100 of these types of trusts. The respondent testified this was his first.
Do we have any questions of counsel? All right, thank you.
Good afternoon, Your Honors. My name is David Crandall. I'm the respondent in this matter. I would ask that this case be dismissed, that the court find that there are none of the accusations leveled against me have merit, and that no penalties be imposed. I think one of the main issues in this case for the court's consideration is, do the ethics rules provide adequate notice to me, in this case, of the accusations that have been leveled? The practicing attorney in Kansas must have some objective means of discerning compliance with the ethics rules. Otherwise, the disciplinary administrator may punish any attorney simply for being an attorney. I have to have some way of determining whether what we're doing is consistent with or in violation of the rules. And I submit that in this case, based on these accusations, it's not possible for me to tell whether I was violating the rules. I submit that I didn't actually violate the rules, but even if there's a finding that I was, I couldn't have avoided it because I didn't know. I could not have known. There are a couple of cases here. One, BA and VA, in which I did estate planning, Medicaid planning, and Veterans Administration pension planning for the clients. This came out of my experience early on doing estate planning, where I took over another retiring attorney's practice and saw many of those estate plans failing. And because of those failures, I didn't want my clients to experience those same things. Because the planning I was doing was basically the same as this other attorney had been doing. I wanted to do something different. I wanted to make sure the clients experienced what they expected. And that's what brought me to seek out greater education. That brought me to the National Network of Estate Planning Attorneys and national experts who practice in these fields. Rick Randall, is an estate planning, national estate planning expert. J. David Kerr, who was my expert in this case, who's a Medicaid expert. James Swain and Victoria Collier, who are VA pension planning experts, and seeking out their advice about how to proceed and how to do this kind of planning. I learned some new things about how to do the planning, things that are unique to the way that I plan and the way that people taught me how to plan. Unique, in fact, in Kansas City area and perhaps in the entire state of Kansas. Some of those are a 3-year agreement for services without additional fee. Mr. Ridenour testified on the record that that's unique in his experience. He's never seen that before. A guarantee that there will be no probate with the client. And Mr. Ridenour also testified that's unique in his experience. He's never seen that before. If we look at this issue, the fee customarily charged in the locality for similar legal services, the requirement is that it be for similar legal services. And Ms. Jansen's testimony was for her services, which are different substantially than mine. And that's consistent with the finding of Mr. Lambrechts, who is the disciplinary...
These unique fee arrangements that you initiated, did you undertake any investigation or advice seeking as to whether or not they complied with the rules of professional conduct, or did you just go ahead and do them?
I took the advice of the experts that were teaching me how to do this, about how to do it. That's what I did.
How did you do that? You talked about your unique fee arrangements with them, and they thought they would be okay, or what do you mean you took their advice?
Yeah, great question. I underwent 2 additional years of training with the National Network of Estate Planning Attorneys about how to do planning. And then on a semi-annual basis, I would attend week-long conferences with them.
How to do planning? I'm talking about the fee arrangements for the planning.
Those fee arrangements, in general, were discussed during that entire time, during the 2 years of additional training, and periodically during seminars at these semi-annual events.
I think the original question was a little more specific than that, though. It wasn't what did you do to train to proceed in this fashion. It was what did you do to investigate? Because you're saying you if you had read every rule, if you hadn't committed to memory, there still wouldn't have been any notice that you might be in violation. So we're asking, what did you actually do to discern that you would not be in violation by proceeding in the fashion that you did?
On the fee arrangement.
Specifically as to fees.
As the fee arrangement. For this case, it would have to be the fee customarily charged in the locality for similar legal services. And in this time, to my knowledge, there was no other person in the Kansas City area in my locality that's charged in this way.
That's
So
that's the question.
Provided this kind of advice and what they advised about charging. And so I knew who were members of the organization and who weren't. I knew that there was no one else in the area charging in this way, doing these kinds of services.
Is there anyone anywhere doing it this way?
Absolutely, all over the country. Mr. J. David Kerr is one. Rick Randall is one. There's an attorney in Chicago. There's an attorney in Denver. There's an attorney in Atlanta. There's over 100 attorneys across the country that are doing planning in this fashion, providing these kinds of services with these kinds of fees.
So are you saying if you're the first one in the field, then you can charge whatever you want?
No, I'm saying that based on the services being offered, if I'm the only one offering these kinds of services, then I have the ability to charge the fees commensurate with the services being offered that are different than what's being offered by other people.
Does the client need to require the services that you're providing? In other words, the trust, you have Q-tip provisions in there, which would be a federal estate tax avoidance maneuver, but they're well shy of the $5 million threshold for having to file a 706. And there are several other very sophisticated maneuvers that these people just simply didn't need. They're in their 80s, less than $500,000 estate with no reasonable expectation of growing that estate to $5 million. But you're giving them a Cadillac when all they need's a scooter to get across the street. And is that permissible under the rules?
There's a lot of pieces to that question. I'll try to address them all. part of it is, Your Honor, that the portion that you're pointing out, some of these provisions in the revocable trust, didn't cost the Alvarados any more than it would have cost them anyway. I didn't, in fact, charge for the revocable trust. If you look at the fee agreement and the way that the billing was done, the fee was really for the Medicaid planning, and the revocable trust was done gratis. There was no charge. That was just for them. And the additional provisions that are in there that are complained about are sweaters in a suitcase, so to speak. If you go to South Carolina in the springtime on a vacation, how are you going to dress? Where are you going to pack? Well, you might put a sweater in the suitcase just in case it gets cold. And a lot of the provisions in the revocable trust are that way. They're things that are included because we don't know what's going to happen in the future. We may know what's going to happen when we're doing the planning, but we don't know what's going to happen in the future. And so there are provisions in there that may not be applicable then, but may be applicable at some time in the future. And why not put them in if it doesn't cost any more? We're generating these documents with a computer program anyway. It doesn't cost them anything to do that. But specifically in this case, Ms. Jansen testified, as a disciplinary administrator suggested, that she would have charged, or that the reasonable fee was $3,000 to $8,000. But she also stated that that would be for 5 to 10 hours of work. So between $1,600 and $800 an hour. The work that I actually put into this case, because of the counseling that I provided to these clients, was about 150 hours. That translates to about $172 an hour effective hourly rate. Over the course of the 3 years that I worked with them for 4 years, so over the course of the 4 years that I worked with them. Ms. Jansen also testified, it's in the record, that she would have declined the representation. She wouldn't have helped these people at all. In fact, she said at the first sign of someone, the family showing discord, she would have been out, and the family would have been on their own. I didn't do that. That's another indication that I offered different services. I offered to counsel with these clients through the difficult times of their family difficulty. And yes, this was my first case of doing this like this, but I took the advice of experts like J. David Kerr, who told me that this is how you charge for this kind of case when you're making this kind of offer to a client to represent them for 3 years, because these kinds of things can come up. And I'm glad I did, because there was a lot of work involved. On the estate of Maria Lopez, the other case, the estate case, specifically with regard to the fee arrangement and whether there was...
Can I just cut you off there because I want a clarification in the record?
Yes.
Is that factual assertion that you just made about the number of hours? Is there any fact finding on that? And I just don't remember. So
I submitted that in the record, Your Honor, as my estimate of the time that was put in, and I gathered that by going back over...
Was there a fact finding made by the panel?
There was no fact finding made by the panel about how much time I spent, no.
Either way?
Either way.
Okay.
On the estate case, with regard to the fee, one of the main issues in the estate case is, does a person, an individual, have the right to claim a homestead in property in which they have no interest? And many of the complaints leveled against me in this case arise out of the disciplinary administrator's position that this individual had a homestead interest, a homestead claim, which I should have advised about and would have altered the fee and created conflicts of interest and all these things. And there was no homestead interest. The facts in this case are that there was a single house when we started the estate. However, very shortly after we started the estate, we came up to the understanding that there was a deed on file, on record, that actually transferred the property to his sisters, the PR sisters. It was a joint tenancy deed signed by the decedent, giving it to them jointly. So there was no interest in the estate in the house. There was no interest in the PR in the house on an individual basis. And so there was no basis on which to assert a homestead claim. Eventually, we were able to get that taken away, and that was with negotiations through the Kansas Health Recovery Program. They had the deeds set aside. But because there was never any homestead claim to begin with, it wasn't an issue, I thought, to negotiate away a claim that didn't exist in order to get some interest in the estate in this house. And that's the basis of many of these claims. Specifically with regard to the fee in this case, a lawyer's fee must be reasonable, But Rule 1.5c specifically states that a judge's opinion is insufficient evidence on its own to determine the breach of this rule. And yet the disciplinary administrator relies almost exclusively on Judge Joyce's opinion. In fact, in the brief, when I argued that there was no evidence offered that the time I actually expended was not accurate or necessary for the case, the only evidence offered in response by the disciplinary administrator was Judge Joyce's opinion. And in fact, there is no evidence in the case to suggest that I didn't actually do the work that I claimed to have done in the estate case. The panel concluded furthermore that the hourly rate I charged was in fact reasonable. There was no evidence presented I did not do the work billed for, and the panel's conclusion that $16,000 on a $35,000 case is per se a breach of Rule 1.5 is not only contrary to Rule 1.5 Comment 3, but it's also not sustainable. If that were true, then an attorney would have to enter into some kind of an agreement with the client that says, you know, when the fees get up to a certain amount, I'm going to have to withdraw because if I continue to work for you, then I'm going to charge more than is reasonable. That's just not a sustainable argument.
What is sustainable in this circumstance? You can spend up to the entire estate and more?
If it is done on behalf of at the request of the client for things that were needed for the case, and that is the case here.
So potentially you could extinguish the entire estate through attorney's fees.
That would be terribly unfortunate, but in this case, there were a lot of things going on in the case. There was the sisters came in and offered an opposing will. They had this deed on record in which they actually owned the only asset of the estate. The amount of the estate also has been mentioned by the disciplinary administrator as $35,000, but while the value of the house was that much at the end, it wasn't actually that much at the beginning. It was more like $100,000. So the value of the estate declined over time. So the argument that it would not have been possible for me to get out of the case at that point. I'm working based on the client's request, based on the circumstances of the case, to provide the counsel and work that is needed. And I billed accordingly. I asked for the fees commensurate with the work that was actually put into it. It's worth noting that I didn't actually get paid anything. So this violation of Rule 1.5 is for a gratis case. $0. I got paid on this case. It doesn't seem reasonable to me either that under KSA 59-1504, where an attorney is permitted to seek compensation from the estate for the services rendered, which is what I did, that I should be held to have violated Rule 1.5 for doing what I'm privileged to do under KSA 59-1504. I see that I'm out of time, and if you don't have any questions for me, I'll take my seat.
Do we have any questions? All right, thank you, counsel.
Just a couple of things. I think the respondent believes that his services are different than other lawyers, in part because of this 3-year continued counseling guarantee that he gives. As pointed out in my brief, there are numerous limitations on that 3 years of continued counseling, including client-initiated changes are not included, telephone consultations, requests for documents, a number of things that are not included. But what's important is that if you read the panel's report, they took into consideration the additional work that the respondent provided in this case, and they concluded, all 3 of them, that still did not make it a reasonable fee. It was still an unreasonable fee. Now, Kimberly Boniface, who filed a dissent, not a dissent, but a concurring opinion, said, I think it's a mitigating factor. He had to do more work, but it's still an unreasonable fee. Respondent also talks about this no probate guarantee, but if you read the no probate guarantee, it says it's only applicable if the client pays an annual $1,500 maintenance fee until death, that the client's heirs hire the respondent, that the heirs pay a death administration fee of 4% or 1%, $4,000 or 1% of the administered estate, and that the probate is required as a result of the respondent's fault and not the client's fault. So there are a lot of qualifications on those guarantees. And the final thing I would say is that
If I could just interrupt briefly on that point.
Yes.
Do you agree that there was no fact finding about how much actual time was put into this particular case?
My recollection is that the respondent testified.
So there's evidence, but there's no fact finding on that point.
Right.
And I guess my question is just, isn't that a pretty important fact when you're determining reasonableness of a fee? And does the failure of a fact finding on that undermine the legal conclusion?
My recollection is that there may have even been testimony that the respondent spent 100 hours after the documents had already been drafted in, and I don't think the panel made that finding a fact, but I think that testimony was in the record.
Right, but I guess my concern is there appears to be no finding of fact. In other words, the panel reached a legal conclusion without knowing or without having an opinion on how much time was spent.
Well, they heard the respondent's testimony, and they heard him testify about what he said he did. And
So we should presume that they believed that then, given that that was the evidence.
Well, I think that's exactly what they found.
Okay.
They took into consideration his testimony about what services he provided, but they still concluded that that did not mean that he had charged a reasonable fee.
Okay.
Have any further questions? Thank you, counsel. Thank you both for your arguments this afternoon. Clerk will take this matter under advisement.